I want to welcome everyone to this afternoon's business meeting, and I'm going to turn it over to Mr. Minges. Oh, before we do that, I want to make sure everyone knows that Commissioner Williams and Commissioner Hamilton are joining us by phone. Go ahead.
Good afternoon, Mr. Chairman, Commissioners. Our next regularly scheduled business meeting will be on Wednesday, August 14th, 2019 at 2 o'clock.
Thank you.
On our supplemental agenda, docket numbers 2019-184, 185, and 186E. Staff presents for Commission consideration Commissioner Williams' request for further discussions regarding future proceedings in these dockets.
Okay. Commissioner Williams, are you there?
I am, Mr. Chairman. Can you hear me?
Yes, we can. It probably needs to be a little louder if we can work that out technically here. We're working on it. Hang on. Try it again.
Hello, can you hear me?
That's better. Thank you.
All right, Mr. Chairman, fellow commissioners, in passing the Energy Freedom Act, the South Carolina General Assembly called upon this commission to address future renewable energy in South Carolina. With great power comes great responsibility, and we have the responsibility to promote a spirit of transparency and fundamental fairness to all parties as we work through this new law. Some parties have asked for a technical conference to discuss avoided cost methodology, but the Commission has been advised that such a conference may violate the rules against ex parte communication. The Commission has been further advised that there are several alternatives to a technical conference for the parties. Those alternatives include allowable ex parte communications, pre-hearing conferences, and pre-hearing briefs. For public record, I want to be clear that any party wanting to present to the Commission may do so pursuant to South Carolina Code Annotated Section 58-3-260 regarding communications with the Commission. For instance, the parties may avail themselves of allowable communications under this section, including subsection C6A. In addition, the parties may request or the Commission may later require pre-hearing conferences and pre-hearing briefs. As mentioned above, the Commission's goal is to promote transparency and fairness to all parties as the Commission seeks to fulfill the General Assembly's intent for the South Carolina Energy Freedom Act. Now, I think all parties involved know most of that information, or they should, which makes me wonder why would some parties still want a technical conference. I wonder whether or not there's information that we will receive in a technical conference that will be hard to communicate through the other methods of allowable communication that I've just outlined. The short answer is I don't know. What I do know is that this law, the South Carolina Energy Freedom Act, is brand new. It changes the way that we're going to do business when it comes to energy in South Carolina. And that may lead me to believe that we may have to change the way we do business as a commission. To that end, I move, Mr. Chairman, that parties seeking a technical conference submit that request to the commission in writing with the schedule and the agenda for how the technical conference should occur. We have no procedure on the books for a technical conference. This is uncharted territory for us. If a party feels that the allowable communications that are presented in our rules and regulations are not suitable to get their point across, based on the fact that the technical conference could do that, I think it's appropriate that we pursue that course of action. Now, I understand there are risks, and the parties surely understand that there are risks. We have to maintain the rules that we have in terms of what can be said in any proceeding before the commission, especially a technical conference, because it's not a hearing. But at the same time, I'm willing to try to do what's necessary to make sure we make the right decision on this matter. Now, if the parties believe that they can get their point across through allowable ex parte communication, which is what the commission normally does, then that's fine as well. But I do not want it to be said that this commission is conducting business as usual and preventing opportunities for parties to come and present information to the commission so we can make the best decision possible as we move forward in these dockets. Additionally, Mr. Chairman, I move that to make this process easily available to all parties in these dockets, that upon request of a party, we waive transcript costs for allowable ex parte briefings related to these dockets and offer to arrange video conferencing for out-of-state witnesses at such briefings. So moved, Mr. Chairman.
Thank you, Commissioner Williams. You've heard Commissioner Williams' motion. Questions or comments? Mr. Belser.
Thank you, Mr. Chairman. Good afternoon, Commissioner Williams. It's good to hear you. Can you hear me?
Good to be heard, Commissioner Belser. Yes, ma'am, I can. Good to be heard.
Thank you for your motion. I do concur in a lot of what you said. I think that everyone here at the Commission wants the information that we need to make a good, sound decision on this new act and the hearings that are coming forth from it. I know that when this matter came up in July, that it was noted, I believe Commissioner Irvin made the motion, that there were avenues for briefing the Commission with allowable ex parte briefings and other mechanisms. I would ask that would you consider a friendly amendment to your motion? I would support a technical conference, but would caution, as you did, that any such conference does need to comply with the state law that governs how we can communicate and how parties can communicate with the Commission. And to the extent that it may help facilitate some sort of briefing or conference, that the parties provide notice and discuss any agenda or mechanism for that with other parties and with the staff to make sure that all parties are heard in a technical conference, as well as setting forth the ground rules or at least some sort of agenda rules to allow the parties to present their positions and stay within the law of governing the ex parte briefings and other matters. I don't think anybody wants to violate the law. I'm concerned about inadvertent communications or getting into matters which may be beyond the scope of an allowable ex parte or briefing or technical workshop. We don't want to violate, the Commission or the Commission staff wants to violate the law, and I don't think the parties do either. But I just think we all need to be aware of potential inadvertent missteps, and let's try to set forth some sort of roadmap where we can all be protected. The Commission can be protected and the parties can be protected. So I would offer that. I would also offer and caution, as all these parties are well represented by very capable and outstanding attorneys, but I think we all need to remember that matters that might be presented in an educational briefing, educational or technical workshop, those are not matters that are in the record before the Commission for decision purposes, and they would have to ensure that any of that information come forth and be put forth in a hearing record, and I would just put that out there as well. So, Mr. Chairman, Commissioner Williams, I reckon I'm asking, would you consider a friendly amendment to allow for the parties and staff to confer to make sure that we have a good roadmap to facilitate any such briefing to protect all parties and the commission staff? Because none of us want to inadvertently violate any kind of ex parte rules or take up matters that are not appropriate for a technical type conference.
I welcome your amendment, Commissioner Belzer. Happy to accept it.
Thank you, Commissioner Belzer and Commissioner Williams. I don't know why when Commissioner Williams speaks, I'm looking up like he's up there somewhere. So, other commissioners, questions, comments?
Mr. Chairman.
Yes, sir.
Chairman, I would
Commissioner
like to
Hamilton.
concur, sir.
I was just calling your name. I was glad to hear you.
Well, thank you, sir. I appreciate that. I would like to concur with the motion as also amended by Commissioner Belcher. I think it's the right track and will give us sound ground as we move forward.
Thank you, sir. Anybody else? Any other commissioners? If not, all in favor, please say aye.
Aye.
All opposed, no.
Aye.
And the motion carries. Thank you.
Mr. Chairman, turning to our utilities agenda, item number 1, docket number 2013-421C. We have a request for confidential treatment.
Commissioner Howard.
Chairman,
Thank you.
Crown Correctional states that it is a privately held corporation and has submitted its financial statements under seal. It asserts that this information is confidential and requests that it not be provided to any parties other than members of the staff who need to review the material for evaluation of the applicant's fitness to provide service. I move we hold Crown Correctional's financial statement under seal as they were filed. However, the burden on Crown Correctional to prove the confidential nature of this material should it be challenged. So move, Mr. Chairman.
Thank you. Heard Commissioner Howard's motion. Are there questions or comments? Not all in favor, please say aye.
Aye.
Opposed, no. Motion carries. Thank you.
Item number 2 on our utilities agenda, docket numbers 2019-184, 185, and 186E. This item concerns the consultant that the commission has engaged in these dockets.
Mr. Chairman.
Mr. Irvin.
Mr. Chairman, members of the commission, the South Carolina Energy Freedom Act, found at Section 58-41-20I of the South Carolina Code, authorizes the Public Service Commission to engage a qualified, independent, third-party expert to work with the commission and to submit a report that includes the third party's independently derived conclusions for each utility's calculation of avoided cost, as well as assists the commission with other issues relating to the new Act's implementation. Last month, the commission asked Pegasus Global Holdings Incorporated to serve in this role after a vetting process. During the vetting, Pegasus was asked to disclose any potential conflicts of interest. At the time of the vetting, the commission was not told by Pegasus that they had been hired by Duke Energy in 2011 in Indiana, where they reportedly earned $3 million to defend a multi-million-dollar Duke project. After Pegasus was retained by the commission, other potential conflicts have been called to our attention by the parties. Our clerk, as a result, has already instructed Pegasus to cease work. I move that we terminate the services of Pegasus for cause based upon their failure to disclose the $3 million contract with Duke Energy in Indiana in 2011, along with other material facts bearing on their independence and experience. Our clerk is instructed to notify Pegasus that they've been discharged effective immediately. I also move that the commission reopen the selection process for the hiring of an independent expert as authorized by law. To promote transparency going forward, our vetting interviews of all future candidates will be held in public here in our hearing room at the Commission. The candidates to be considered will be placed under oath, and the interviews will be recorded by a court reporter and transcribed, and a live streaming will be available for public viewing. All candidates will be specifically asked to answer questions about their independence, their experience with the issues contained in these dockets, and any potential conflicts of interest that might affect their credibility to serve in this role. As potential applicants are scheduled for public vetting by the Commission, they will be identified on the Public Service Commission's website. To further ensure transparency and allow the parties to participate in this vetting process, the attorneys representing the parties to these dockets will be allowed to submit proposed written questions to our clerk, Ms. Jocelyn Boyd, by way of the docket management system concerning each of the candidates who will be interviewed. These questions can certainly assist the Commission to determine whether the candidate has the ability to serve as an independent expert. These written questions from the attorneys should relate then to the candidate's independence, qualifications, and experience in the field of utility regulation, rate making, and the like. Proposed questions for specific interviewees must be submitted within 48 hours after the notice of interview has been posted on the Commission DMS. We are in the process of scheduling the first round of interviews for next Monday, so I would encourage the attorneys representing the parties to the docket to watch carefully as we confirm these interviews that will be posted on our docket management system, and that then triggers your time to submit questions to be considered by the Commission as we interview and vet new candidates for the position of independent expert. Mr. Chairman, I move then that we discharge Pegasus, that we reopen the selection process as described in my motion. So moved.
Thank you, Commissioner Urban. You've heard Commissioner Urban's motion. Are there questions or comments?
Mr. Chairman,
Commissioner Whitfield.
I have something for Commissioner Urban, if you bear with me 1 second.
And Mr. Chairman, I have a few comments as well. I'm going to put my phone back on mute and wait until Commissioner Whitfield finishes.
Okay, when I will call you or call on you.
Absolutely.
Mr. Chairman, I just have I guess a little bit of a comment and a question for Commissioner Urban. I certainly commend you, Commissioner Urban. We had some discussions before. As you are aware, and others may be aware too, ethics rules prohibit us from all being together, and some of us were able to meet these folks in person, and some of us were not. We've had that discussion, and I certainly applaud what you're doing here. If the Commission one thing we were certainly doing was moving fast. And I think we were trying expeditiously, is the word that some of us may have used, to comply with Act 62. And sometimes when you're moving expeditiously, things don't always come to light that you now have pointed out. And I certainly applaud your motion and appreciate your going the extra mile to work with our clerk, Ms. Jocelyn Boyd, to ensure a transparent and very public process going forward. I certainly concur with your motion, and I'm going to support it. Thank you, Mr. Chairman.
Thank you, sir.
Thank you. Commissioner Williams.
Yes, Mr. Chairman.
Thank you, sir.
Mr. Chairman, I want to discuss two topics. The first is responsibility, and the second is perception. We're responsible for our decisions. Good leadership requires self-accountability for mistakes and the ability to create a path forward, a clear path forward for that matter, to correct said mistakes and ensure future success. Commissioner Irvin, I think your motion does that, and I'm proud to support it. So there are a few other issues I want to address. As members of the commission, we have to accept responsibility for moving too fast on selecting a consultant for this project. It happens to be Pegasus in this instance, but I believe that we would have been in a similar situation, if not the same situation, with another consultant because we moved too fast and missed something. It's not uncommon to move too fast, and the commission is not above any other human. As opposed to having public interviews that were live streamed, we conducted in-house interviews. While that course of action was not wrong, it was not the best practice because it's led us back to start this process again. Despite the fact that I, along with many other, if not all of my fellow commissioners, repeatedly asked Pegasus if they had a conflict of interest, they did not disclose that they had a $3 million contract from Duke. I voted for Pegasus because they have a wealth of experience in handling issues like these. I've worked with expert witnesses and consultants before as a trial lawyer. In that vein, I believe the best consultant is one who has direct experience working in a particular area and possibly for a particular entity, and thus will be familiar with how that entity operates. So in the event there's ever a time where I feel a party is not being as transparent on an issue as they could be or presenting alternative facts, I can go to my expert to determine whether they're fudging or not, because they have that direct experience. That said, I believe Pegasus has disqualified themselves from serving as the Public Service Commission's expert because they did not disclose pertinent information when they interviewed with the Public Service Commission. I do not think Pegasus truly appreciates the current climate that we are in. There's no room for mistakes or excuses in our current operational environment. I want to talk about perception, and I'll close, Mr. Chairman.
Come in. Yes.
To my fellow commissioners and commission staff,
have my meeting, my medicine. Pain
we have not regained the public trust. While I think we have made progress, we still have more work to do to remove ourselves from the whipping post.
Hang on, Commissioner Williams. We're getting some interference somewhere.
All right, thank you.
I feel like I'm in the movie Hair. Okay. Continue, Commissioner Williams.
I know that we're all highly qualified professionals and that we're used to being given the benefit of the doubt, but we do not get the benefit of the doubt in this operational environment. I believe we should ask ourselves in all of our decisions, how will our decision be perceived? Because whether like it or not, perception is reality. We must make sure that each decision we make promotes transparency and fundamental fairness. We should use the technology available to live stream and record the interviews for consultants and any other matters for that instance. It may be that promoting transparency, fundamental fairness, and restoring the public trust may be contrary to judicial economy, but transparency, fairness, and regaining the public trust is more important to me than judicial economy. For those comments, Commissioner Irvin, I fully support your motion.
Thank you, Commissioner Williams. And let me say that we did feel a sense of urgency to try to move forward because we have certain statutory deadlines. We're aware that 6 months from the date that the governor signed the act, we have to render a decision. So I think it's fair to say we did feel time pressure and we did rush the process forward. And so we're going to take this action today, hopefully in a unanimous vote, which can restore the public trust and the trust of the parties and participants, because we want to get it right and we want to be fair and impartial and transparent. And so we're moving our vetting process from behind closed doors into the open public forum. We'll have a record. Everybody will have a chance to be heard. We'll have a transcript. We'll have the witness under oath, so that if later it turns out that they weren't fully truthful, then appropriate action can be taken.
Hey, sir.
So with that, Mr. Chairman, I move the adoption of the motion.
Mr. Chairman.
Commissioner Hamilton, if you're there, we need for you to mute your phone, I think. We're getting some.
Yeah, I'm sorry. I thought it was on. Excuse me.
Thank you. Sorry, Commissioner Irvin.
That's quite all right. And so with that, I think that unless others need to be heard, I think they may, I'll defer to my fellow commissioners.
Commissioner Whitfield.
Mr. Chairman, if I could just address a little bit Commissioner Irvin's last part of your motion. With the process going forward, back to where we were, we know, and we know going forward, that people with this type of expertise are not plenty, and not in big numbers. And we know that finding folks with this type of expertise to be an independent consultant for us on avoided cost methodologies are sometimes difficult to find. And I can share personally, firsthand knowledge as chairman. We had an electrical engineer retired during my chairmanship, and to find an electrical engineer under the parameters that we had in state government was just not possible. So these are highly specialized expert folks, and we know going forward that we're going to have to really scrutinize and to find that right independent expert consultant that will be our consultant and will be our advisor, just like one of our own technical or legal staff advisors here at the commission. So that's what the commission has charged, what we are charged with going forward. And the public, because of if we approve your motion, will be able to see that process live and in real time. Thank you.
That's a good point, and that is a difficult process, because anyone that's had prior experience in rate making or in utility regulations is most likely going to have worked for a publicly owned utility at some point in their career, or a solar provider, or some other related field. And so that's why we need an open, full vetting process. We have to tease out those prior contacts, see if they prejudice the experts' ability to be independent, truly independent, and consider all the surrounding facts and circumstances. I hope we can do that in a very open process here in this room. And, but it's going to be, I frankly think it's going to be difficult to find someone who's never had any contact with a publicly owned utility. By nature, they're going to have been involved some way. Now, we might find an academic person that teaches courses on utility regulation. It's never worked for utility, but I just say that because the fact that they may have had some contact with the utility does not in and of itself disqualify them. It's provided they can still be fair and impartial and independent. So we're gonna work through the process. One suggestion that I have made is that we have a National Association of Utility Regulators, which is a nonprofit, and they have a research arm, and perhaps we may see fit to interview them to see if they could give us some guidance in this area, because they do serve other commissions around the country. And they would, in my mind, be certainly independent of any past or ongoing work with utilities. I would think they would be. But we'll see. We'll hear from a number of candidates, and we'll vet them carefully, completely, and then make some decisions.
Thank you, Commissioner Irvin. Anyone else? Commissioner Howard.
Mr. Chairman, I'm going to probably abstain because I'm concerned about a time frame. I guess in my mind, I don't see why we're conducting interviews in 3 days. We were asking the party to submit something within 48 hours. I got one of these resumes this morning. It's like 12 or 13 pages long. God knows how many documents and papers he's written. And there are probably 3 or 4 out there. And I just think the compressed time of interviewing these people Monday and expecting them to be prepared or the other parties to be prepared, I just think is too quick, and I think we might be stepping on our foot, and so consequently, I'm not comfortable with the motion and then with the time frame of interviewing Monday. I think another week, and I guess maybe I don't understand the need for the expedition review of this, but I'm just personally uncomfortable with it.
Let me suggest this, and I appreciate your comment. My staff, Ms. Boyd, has been working to try to locate independent qualified experts. It's my understanding she may have already invited some to come next week. Is that correct, Ms. Boyd? Could you tell us?
We'll ask her to get to a microphone.
Good afternoon, Mr. Chairman. Judge Irvin, after the commission was contacted on Friday regarding some information regarding the experts in the 184, 185, and 186 dockets, we answered some questions on Friday evening at the commission, and then I returned to work on Saturday morning to try to do some more research. So I don't mind. It's going to be published here shortly, and this is a public meeting. So I spoke to Dr. Carl Peckman with NRRI.
Tell us what NRRI stands for, please.
I think it's the National Regulatory Research Institute. I'll go over on the web for just a second and confirm that, Judge.
And I believe they have a website.
They do. It's
NRRI.org.
NRRI.org.
So if anybody's interested, they can go to their website and learn more about the institute.
That's correct.
It's a nonprofit institute.
Yes, sir. So on Saturday, I spoke to Dr. Peckman. We spoke a couple of times, and I asked him again. I saw him at NARUC, but we were actually talking about the commission's relationship with NRI, which is an arm of NARUC, which you all are well aware of. And I asked him, would he be able to provide information to you? All right, thank you. About being one of your, talking to you. So Dr. Peckman, and that was on Saturday morning. He and I spoke a couple of times, and he said yes. So go ahead and put it out there before we notice it. He's supposed to be here, and that was last Saturday. He's supposed to be here this coming Monday at
Where is he from?
10 o'clock. Golly, all I can tell you right now,
Washington,
Judge, is he
D.C.
told me he's vacationing in the Outer Banks
Okay,
right now
all
this
right.
week.
But you'll be posting his name and,
I'll be posting his name. I also spoke to someone else, another entity down at the University of Florida. I've spoken to an attorney down in Florida. His name will also be on the notice that we issue after this meeting. He will be here on the 19th. We have 2 other people on this coming Monday, and they've agreed to talk to you via Skype. So I understand what Commissioner Howard is saying. I think one of the emails he's referring to is information. I'm still talking to those people. So, and they've not been scheduled yet.
all right,
But,
well, let me ask you this, just so that we can give the parties as much notice as possible. Could I amend the motion that you go ahead and put what you have scheduled for next Monday and the following Monday? Can you go ahead and post that information
We will
as
post
soon as
it.
we finish
We'll
the
post it
meeting?
before close of business today. Yes, sir. I
Great.
want to make sure there are no errors in our notice. We've been working on it.
They
But I
could
just want
begin
you-
their research and vetting on their
Sure
own,
can.
and
Sure can.
who's scheduled first on Monday?
First is NRI,
Okay.
and then Paul Chernak. He has several years of experience. Actually, he was a witness for our Department of Consumer Affairs when the Consumer Advocate appeared here. The last time he said he appeared before this commission was in 1992. So you'll be hearing from him at 1 p.m. And then, Judge, I don't remember right now who my second person is.
You just post what you have confirmed. That
sir.
way, everybody will be on the same page.
Oh, okay, yeah, thank you. Rick Sedana with, I think it's the regulatory, it's a project. I don't recall the exact name, but he's coming at 11:30. Thank you, Norman.
So just, when you get back to your office and have your file in front of you, just post all that information.
Yes, sir.
So everybody has it available and they can begin their own vetting process.
Yes, sir, they sure can.
Very good. So I think with that, we're giving everybody ample notice. I know it's probably a tight schedule, but I think it's necessary that we move forward because of the time deadlines we're facing. We need to have someone on board to assist us as soon as possible. So
What is the deadline? What deadline are we facing? What's the date?
we have to file an order by November the 16th.
Well, actually, Judge, you have to rule in this matter. You have to rule by November 16th. That's 6 months from the date of the governor's signature.
Right.
And I think the meeting that week, the normal regular scheduled meeting, would be like November 13th. That's that Wednesday. But if you have a special meeting on that, I think that's actually what? Friday?
Well, for example,
Saturday?
Chernick. You mentioned Chernick a while ago. Looked up Chernick last night, and I went to his bio, and then I went to LinkedIn, and he had like 4 or 5 people that were his LinkedIn partners, whatever you call them, that I know, and I anticipate on calling each of them. Well, that takes time, and I mean, to see what they know about him, and consequently, that's just one out of how many you mentioned. Now, personally, I'm very familiar with an RRI. I know Carl Peckman, and so I have all the confidence in the world in those. But I just, these other people I don't know. Rap I'm familiar with. A lot of them I'm familiar with, but some of them, I am not. And it's a pretty sensitive subject we're dealing with. And maybe I'm just a slow learner, but I would like more time.
I mean, Commissioner Howard, I think everybody's heart was in the right place here, trying to fulfill the requirements of the act. And I even mentioned to staff earlier today. Remember, I came back twice on 2 issues when we first started presenting this, the interconnection timelines. Thought we'd read that the right way, had the advisory meeting, everybody else had a different opinion. The integrated resource plans, we had an extensive dialogue in this commission hearing room. Other people who knew what the intent was, we were not present. So, and I think you have to start somewhere. I think Vice Chairman Williams mentioned it right. You're human. I think the only flaw is when you don't try. We tried, and I think if we continue...
Not to get into public debate, but...
No, I'm not trying to.
This only came about Friday when we let the current contractor go. We had a contractor in place. Everything was fine. And I'm not saying let him go with a bad move. I think it was the proper thing to do. But however, the process just started off recently. It's not going back 2 weeks. The process to evaluate a consultant is just starting off right now, so to speak.
Well, I want to ask this question then, do you all want to start finding out what you know, and then you can kind of find out preliminary information and see how far you want to pursue that particular prospective consultant? I think what you're saying is you feel like it's moving too fast, and I think perhaps the presentations that you're going to hear from on the 12th and the 19th are just the beginning of the process.
That's correct. We're not making the decision right then. We're starting the process to hear what we need to hear.
Okay.
Yeah, I thought that was the purpose of it, to start the process, not for you to vote and make a decision.
All right.
No, I would not want to vote until we've heard from all the candidates, and we're trying to identify those that we think may meet the statutory requirements.
Yes, sir. I thought
Independent expert
right
in the area that we're dealing with on these dockets.
Yes, sir. I thought that was the purpose of this,
Right.
not for you
So,
to vote, but for you to
That's
get.
right. We're not going to vote until we get to a formally called business meeting, but we will get a chance to vet them.
Yes, sir.
And I would point out that this doesn't have to be the only interview. If we
That's right.
want to ask them follow up, if we want to follow
That's
up,
right.
we want to talk, we're going to make sure we're as thorough as possible. And so that's not the only shot.
And I will add, Mr. Chairman, we have the added advantage. The attorney, one last note, that I spoke to on Saturday also said, look, I will drive from Florida. But we've since learned we can use Skype. So if you do need to re-interview someone, it's really not, they can stay in their home or wherever, and you can talk to them from there.
Thank you. Commissioner
Chairman,
Whitfield.
one quick question, Ms. Boyd. Ms. Boyd, I said a little while ago that there aren't a ton of folks running around doing this. In your early opening back up of this process and searching, you'd concur, wouldn't you, that there's a finite number of folks that are qualified, and this is a small pool of folks that we have to choose from, right?
Commissioner, I would, from the names that the firms and individuals that I've spoken to thus far, either they appear to have maybe not as much experience as others,
Right.
or they have worked for one of our investor-owned utilities in some capacity. But as I've mentioned to a couple of commissioners, I'm not necessarily not giving y'all those names because to what extent? I think that's where this public vetting.
Right.
And you're asking questions to see, okay, maybe what they received was $500 20 years ago.
Mm-hmm.
Is that independent or not?
Right.
This is the first time that I can recall that an issue like this has come before this commission. Maybe that's the beauty of this public process.
Yes, ma'am.
It's a novel issue before you all, and maybe that's why it needs to be handled differently.
But it's certainly fair to say that
I would say
with small number of folks.
I would say a small number, yes, sir.
Yes, ma'am. Thank you, Mr. Chairman.
Thank you. Anything else, commissioners?
Hey, Mr. Chairman, this is
Yes, sir.
Vice Chairman Williams. I wanted to ask Commissioner Howard how much time does he think is appropriate to give himself ample opportunity to review a candidate, not necessarily a specific candidate, but just any candidate. What type of process would you want to go through to feel comfortable that you fully vetted a candidate? And how much time do you think you would need?
That's a good question. I can't answer it, Commissioner Williams. I would say 2 or 3 days. It depends on the in-depth of the experience of the particular party, how much you would have to look at, and, just I guess, to check him out. So, I can't answer that, but I think a week would be a normal amount. I think 3 days is not.
Mr.
And
hang on.
I appreciate that, Commissioner Howard. Ms. Boyd, and maybe Ms. Boyd, I think you're the appropriate person to address this question to. In terms of the public comment period, are you saying that once we post the experts' curriculum vitae
that we will have an open period for the public and or all parties to make comments?
I think Judge Irvin's motion basically stated that for those who are interested in asking questions of the persons or entities' names who are listed in the notice for the interviews, those are the questions that they would file through DMS.
All right, that's in the motion.
Okay, all right. Thank you.
Thank you. Anybody else? Commissioner Urban?
I think we're ready to vote.
Okay. All right. If no other questions, all in favor of the motion, please say aye.
Aye.
All opposed, no.
Mr. Chairman, I abstained.
Okay. Motion carries. Thank you.
Mr. Chairman, that concludes our utilities agenda. Turning to our transportation agenda, items number 1 and 2 are new applications that can be taken together. Item number 1, docket 2019-259T, the application of Cardis Green, DBA Always On Time Transportation. And item number 2, docket 2019-261T, is the application of ASG Transportation, LLC.
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman, I move that we approve the new applications as identified by Mr. Menges in items 1 and 2. So move.
Thank you. You've heard Commissioner Whitfield's motion. Are there questions or comments? If not, all in favor, please say aye. All opposed, no. Motion carries. Thank you.
Item number 3, docket number 2019-95T, we have a request for an extension of time.
Mr. Chairman,
Commissioner Belzer.
I move that we grant National Mobility Service, Inc.'s request for an extension of time until February 29th, 2020 to comply with Commission's rules and regulations. So move.
Thank you. You've heard Commissioner Belzer's motion. Are there questions or comments? If not, all in favor, please say aye. Aye. All opposed, no. And the motion carries. Thank you.
Item number 4, docket number 2019-102T, we have another request for an extension of time.
Chairman.
Commissioner Howard.
Chairman, I move we grant the request of Joyful Time Rides, LLC, an extension of time until November the 4th, 2019, to comply with Commissioner rules and regulations. So move, Mr. Chairman.
Thank you. You've heard Commissioner Howard's motion. Are there questions or comments? If not, all in favor, please say aye. All opposed, no. The motion carries. Thank you.
Chairman, that concludes today's agenda.
Thank you. There's nothing else to come before the commission. We are adjourned.
Testing 1, 2. Thank you for joining us for today's post-meeting summary. These commission business meetings are usually held each Wednesday at 2 p.m., and all agendas and materials are posted to the docket management system before each meeting. If you have questions about commission business, we encourage you to reach out to us at robert.bachman@psc.sc.gov or via social media by following the SC Utility Consumer Program on Twitter at Utility Consumer or on Facebook at SC Utility Consumer. Today's business meeting started at 2:04 p.m. with a supplemental agenda, which was Commissioner Williams' request for further discussion regarding future proceedings in dockets opened following the passage of Act 62, the South Carolina Energy Freedom Act. Commissioner Williams, calling in from offsite, brought the motion to clarify the process for those wishing to present information to the Commission per these dockets or to schedule a technical conference. Quoting from his motion, quotes, "Parties may avail themselves of allowable communications under this section, including subsection 6CA, In addition, the parties may request, or the Commission may later require, pre-hearing conferences and pre-hearing briefs. My motion today reiterates that the Commission's goal is to promote transparency and fairness to all parties as the Commission moves through the uncharted territory of these dockets. Further, to make this process easily available to all parties in these dockets, I move that, upon the request of a party, we waive transcript costs for allowable ex parte briefings related to these dockets and offer to arrange video conferencing for any out-of-state witnesses at these briefings. End quote. Commissioner Belser concurred with the bulk of this motion, but asked that Williams consider an amendment that supports a technical conference, but requires that all such conferences are governed by state law, including providing notice, drafting agendas, and setting ground rules to ensure fairness and efficiency within all communications. She described it essentially as, quote, a roadmap that ensures rules are followed. Commissioner Williams voiced his approval for this amendment. Commissioner Hamilton, also calling into the meeting, then concurred with the motion and the amendment proposed by Commissioner Belser. The Commission then voted to pass this motion. The Commission then moved on to the first item on the utilities agenda, a request made by a telecommunications company for confidential treatment of its 2018 balance sheet. Commissioner Howard made the motion to grant this request, which carried. Item 2 involved Commission discussion and action on the previously announced hiring of Pegasus Global Holdings Incorporated as a third-party consultant. Commissioner Irving made the motion to dismiss Pegasus, noting that during the vetting process, quote, we asked Pegasus to disclose any potential conflicts of interest. We were not told by Pegasus that they had been hired by Duke Energy in 2011 in Indiana, where they reportedly earned around $3 million to defend a multi-million-dollar Duke project. After Pegasus was retained, other potential conflicts have been called to our attention by the parties. Our clerk, as a result, has already instructed Pegasus to cease work. I move that we terminate the services of Pegasus for cause based upon their failure to disclose the $3 million contract with Duke Energy in Indiana in 2011, along with other material facts bearing on their independence and experience. Quoting from Commissioner Irving's motion, quote, our vetting interviews of all future candidates will be held in public here in the PSC hearing room. The candidates will be placed under oath and the interviews will be live streamed. All candidates will be specifically asked to answer questions about their independence, their experience with the issues contained in these dockets, and any potential conflicts of interest that might affect their credibility. As potential applicants are scheduled for public vetting by the Commission, they will be identified on the PSC website, end quote. Attorneys for parties involved in the dockets will also be allowed to submit questions to determine if candidates can serve as independent experts. Following the introduction of Commissioner Irving's motion, Commissioner Whitfield voiced his support. Commissioner Williams then supported the motion, but noted that responsibility must be accepted by the Commission for any issues arising from the compressed time frame that led to Pegasus's retaining, the agility of in-house interviews being preferred at that time, and that he feels a firm with great experience in the field is paramount, but that Pegasus has disqualified themselves by not, quote, disclosing pertinent information, end quote, and that the firm, quote, does not appreciate the current climate we're in, end quote, and that retaining the public trust is vital. Jocelyn Boyd mentioned that she has had contact with several potential candidates and that all information will be posted on the PSC website at www.psc.sc.gov. This motion then carried with Commissioner Howard abstaining. In addition to the items discussed during the transportation section of this meeting, the commissioners were advised on 36 other utilities-related issues, utilities section of this meeting. You can find the complete list of these items, along with the docket information for each, on the Docket Management System website at dms.psc.sc.gov. Moving on to the transportation agenda. Today's meeting agenda contained 2 new applications for certification for operation of a motor vehicle carrier. These requests were both granted following a motion made by Commissioner Whitfield. The Commission then considered items 3 and 4, 2 requests for extensions of time for motor vehicle carriers to comply with Commission rules and regulations. These requests were granted following motions made by respectively Commissioners Belser and Howard. In addition to these matters discussed in detail, Commissioners were also advised on 3 more transportation-related issues. You can find the complete list of these, as well as links to the docket materials for each, and orders issued by the Commission through the docket management system at dms.psc.sc.gov. That's, again, dms.psc.sc.gov. The next Commission business meeting will be at 2 p.m. on August 14th, next Wednesday. The meeting will be live streamed on our website at www.psc.sc.gov. If you have questions about today's proceedings, please follow us on social media to address those. On Twitter at PSC of SC, or on Facebook at the Public Service Commission of South Carolina. Again, that's on Twitter at PSC of SC, or on Facebook at the Public Service Commission of South Carolina, or call our offices at 803-896-5100. Thank you.